courtroom, please rise. Court of Appeals is now in session. Please be seated.
Good morning. Welcome to the Utah Court of Appeals. I'm Judge Ryan Harris, and with me today are Judges Michelle Christensen Forster and Judge Ryan Tenney. We're happy to be here to entertain your arguments in case number 20220352, State versus Cortez-Izarraraz. I'm going to have to depend on you to tell me if I mess that up or not. And I'd also like some input on how to refer to your client during the argument today. Is it Mr. Cortez or however? So when it's your turn to stand up, and maybe you can start by addressing that. Let me start by asking counsel to make their appearances for the record. Let's start with counsel for the appellant.
Heather Ellison on behalf of the appellant Omar Cortez-Izarraraz.
Good to see you, Ms. Ellison, in the courtroom sitting here instead of there. Mr. Bauer.
Jonathan Bauer on behalf of the state.
Good morning to you as well. Okay, any questions before we begin? Both of you have at least seen many arguments in this courtroom. 12 minutes on the clock, so I assume there's been some communication about rebuttal time. Are we ready to go?
Yes.
All right, Ms. Ellison, look forward to your argument.
Good morning, Your Honors, counsel. As to your question about how to refer to our client, we thought Omar would be the easiest and consistent with how we refer to him in our briefing.
Okay.
Omar should be granted a new trial because he received ineffective assistance of counsel in 3 ways. I'll begin with the ineffective assistance claim from the 23B motion about the biased jurors. Omar's trial counsel was ineffective by failing to sufficiently inquire into the potential biases of Juror 6 and Juror 7, which resulted in 2 actually biased jurors sitting on Omar's jury. Counsel was concerned about Juror 6 and Juror 7's close connection to law enforcement, but instead of probing those jurors further, counsel simply made a motion to dismiss Juror 6 for cause and took no other action, and that was ineffective assistance. We know from this court's recent opinion in Taylor that voir dire responses revealing evidence of bias or partiality give rise to a presumption that a potential juror is biased, and the juror must be dismissed unless that presumption is rebutted. And that did not happen here.
The state's response to the argument you're making in the 23B motion was to catalog all the questions that had been asked, mostly by the court, and to simply say that I think that the information that was already out there gave counsel basically everything counsel needed. What additional question do you think counsel should have asked if counsel had tried to open this up more that wasn't already asked?
Your Honor, I believe rather than getting into specifics of questions, like the principle really is whether a question could reveal, as it describes in Taylor best, whether a juror's statement of bias is one that is just the product of a light impression or one that reveals that this juror would have a tendency to close the mind against the testimony that would be offered.
I mean, yeah, that sort of gets to the nub of this issue. I mean, I find it compelling, to be honest, what you've produced in your affidavit. Once a couple years later, you get these 2 jurors saying things along the lines of, I'm going to lean towards the cop in terms of credibility. I think we have a problem. But what strikes me about the state's response to that is, at the time, during voir dire, they had already sort of been asked that question, and they had already said, no, I can put that aside. And so I'm just not totally sure what it is in that moment of voir dire that should have prompted counsel to think, oh, we should ask that question again. The question that's already sort of been asked and answered. Like, what's the value in defense counsel's mind of saying, let me take another crack at it? That's what I'm struggling with.
Sure, Your Honor. Well, I think we have to remember a juror's assurances alone are not enough to rebut a presumption of bias, so I think it's valuable to dig deeper into the outward appearance of bias that was evident because of both of these jurors' close connections to law enforcement. So asking more specific questions, for instance, we know Juror 7 had a father and a brother who were both involved in law enforcement, and that juror was just steeped in law enforcement culture his whole life, right? He explains, but we don't know really the nature of those relationships, you know, how, were they close, or?
You go. No, you go.
Oh, I insist.
Okay, now I have to. But in Taylor, the responses from the veneer, from the potential jurors themselves reflected the bias that they may have had, or that they had, come to find out. Here, there were what responses from the jurors themselves, the potential jurors themselves, indicated their bias rather than just an impression of bias. Do you see what I'm asking in the
Yeah.
distinction?
Yes, Your Honor, there is that difference. But I think that goes to the problem that the jurors were not asked specifically and given the chance to even give responses that could have leaned either ways. It was just, I think, the fact that they were so closely tied to law enforcement that flagged to counsel that they needed to be investigated, that potential bias needed to be investigated further.
So on the question of the depth, you talked about they're steeped in law enforcement. In fact, Judge McKelvey appeared to know the father of juror
Yes.
number 7, and so I think the court was well aware of how steeped at least juror number 7 was in the law enforcement culture. But for the purposes of today's motion that you're making, I'm interested in knowing what it is you think we learned more about their relationship with law enforcement in these affidavits that the court didn't know and the counsel didn't know during voir dire. I put the questionnaire next to these affidavits and I'm having trouble coming up with any new details about their relationship with law enforcement. Do you see any new information about their relationship with law enforcement that your investigators got in these affidavits that the court didn't already have?
I think if we turn to the declarations, they give evidence that is sufficient to keep in mind that we're at a 23B level here. And I think that there is sufficient in here to show actual bias to get to a 23B hearing, which, according to our Supreme Court, is the best avenue to really suss out actual bias. And I just would say that it's objectively unreasonable that counsel moved to strike juror 6 for cause without first, as you say, establishing that there was bias. There wasn't enough evidence for which the court to rule. And to be fair to the trial court, I think the court was more concerned about the implication that you just categorically exclude law enforcement, and we don't do that. As you know, law enforcement can certainly serve as jurors, and there is no categorical exclusion for professions. Generally, you know, a judge can serve on a jury as well. So
Yeah, right.
that's
So,
where,
so on
yeah,
that point,
unreasonable.
we know that juror 6 and juror 7 have pretty deep connections with law enforcement. But that's not a categorical exclusion. You have to then ask the question, would your association with law enforcement cause you to give law enforcement witnesses more credibility than other witnesses? And that question was specifically put to them in the questionnaire, and they both answered that they wouldn't give law enforcement officers more weight. And then the court asked that question again out loud, and they're supposed to show their hands, and neither one of them does. So I think, going to Judge Tenney's point, I think they're asked that question not once but twice, once in writing, once orally, and there isn't any equivocation in either answer. So I guess I'm just restating Judge Tenney's question, like, what is counsel supposed to do in that moment? Counsel doesn't have an equivocal answer on that point that would merit additional probing, does he? Or she? Can't remember what the gender of counsel, excuse me for gendering counsel, but does counsel have any information there that would cause him to think that they should dig deeper about that?
Well, we know from the record that she was concerned with, in particular, juror 6, and that's why she made the motion for cause to remove juror 6. And I would just point to our case law that says that, you know, it's trial court's responsibility to really uncover potential bias, and especially at this stage of trial where it is so easy to do so, to just stop and ask, like those jurors in particular, not just in a group and say, if you don't agree, didn't raise your hand, but just to take those additional steps, especially given how damaging even just one biased juror is on a trial.
I guess I still am trying to close the loop in my mind, and this is, again, I think a restatement of Judge Tenney's question, exactly what it is you think counsel should have asked in that moment. Okay, so let's take juror number 6, let's isolate them back in chambers or wherever, and let's ask them what? Ask them again the same question, or ask them something else?
Perhaps even again the same question, but directly directed at that juror. And I think, again, turning to the declarations, even juror 6 himself stated he was surprised he didn't get more direct questions about who he knew in law enforcement, whether he was close to those people, and how he worked with them, and just asking how that would influence his ability to, not just understand, but apply the presumption of innocence, and whether he would give more weight to a law enforcement officer. I think that it's objectively reasonable.
It doesn't
to
look like
expect
your
that.
investigator asked those questions either, because I don't see any new information in the declarations that we don't already have in the answer to question number 42 on the questionnaire, where he says, I'm involved in the law enforcement community. I currently work as EMS. I have close friendships with law enforcement officers from 6 different law enforcement agencies. There's nothing new in the affidavit that I can see. So not even your investigator asked those questions. I guess I'm struggling with why you think the counsel should have, it's constitutionally ineffective for counsel not to have asked those in that moment.
I would say, Your Honor, I respectfully disagree. I do think we uncover more bias in those declarations, and had counsel asked more questions during the voir dire or asked the trial court to dig deeper, we could have learned, for instance, that juror 6 says he would have put more credibility toward law enforcement and leaned closer to law enforcement in most cases, as well as that juror 6 believed that it was not typical that the police arrest the wrong person. And so, again, I would say we're asking for a 23B remand, which I think would be an appropriate avenue to explore deeper into the jurors' bias and determine whether it was actual bias that would warrant a reversal and a new trial.
Can I take the other issue, unless we want to?
Yeah, I was going to go there too, so go ahead.
Happy to let you. Okay, let me take the other issue. As I understand it, the crux of your argument on the merits brief issue, is that because they're similarly situated in terms of the facts that lead to the potential charges, that the Uniform Operation Clause kicks in and guarantees your client a right to the imperfect self-defense. Do I have the base construct right?
Yes, Your Honor.
Oh, okay. Why doesn't the mere fact alone that we're dealing with different charges that have different, well, it's not one fact, but different charges with different elements with a different sentencing range, why doesn't that pull us out of the similarly situated rubric? Okay.
Your Honor, I would say because if we distill it down to the conduct, a defendant who fires a gun and seriously injures a person, as occurred in this case, can end up in 2 different places.
So is the thing that makes them similarly situated the factual overlap?
Yes, Your Honor, whether someone...
So I'm struggling, and I'll let you talk. I know I keep cutting you off. I'm struggling with how we would write that rule. I mean, how we would write the rule that would define factual overlap for purposes of a uniform operation analysis. It just feels to me like there's something of a Pandora's box there, and the devil would really be in the details. How would we write that?
Your Honor, I agree that the critical component is that a similarly situated inquiry is fact-specific.
Okay.
And I think we do have a lot of case law that indicates that when we're considering that question, we look at the circumstances.
Okay, so let me ask you the follow-up then. Okay, now I'm cutting you off again. Suppose you have a set of facts that could lead to a greater offense and a lesser included offense. Would it violate, in your view, the Uniform Operation Clause to have a different statute of limitations applicable to the greater versus the lesser, or are they required by Constitution to have the same statute of limitations?
That is a good question, Your Honor. I would say that I am two parts.
Yeah.
One, that including the statute of limitations would be more beneficial, so I would argue that that would be included. And then two parts, the second part would be just kind of getting back to the facts of this case, that it's just the established principle, the uniform operation of laws, matters here because we see that Omar was precluded from being able to even articulate imperfect self-defense when it would have more suitably applied here. And that's, the unfairness lies in just the fact that the state chose to charge him under felony discharge of a firearm when they could have as well chose to charge him under attempted murder. So it just kind of illustrates the unfairness under that statute and how it violates the uniform operation.
I mean, I will
laws.
say, in all the criminal appeals that I've been involved in, both as an attorney and as a judge, I'm not sure that I've ever heard a defendant argue that the problem was that he was undercharged. And so this is a little bit unusual to me. When I take the point, I mean, I think your point is that the state may have undercharged him precisely to get around this problem.
Well, Your Honor, I think before we consider him being undercharged, we look at the sentencing, and a sentence for attempted murder is 3 years to life, whereas felony discharge of a weapon is 5 years to life. Moreover, by the state charging him with felony discharge, it was allowed to stack those charges. So they were able to charge him with 7 counts of felony discharge of a weapon versus just one
count of
attempted murder.
I take that back.
So, no, I mean, at first glance, you think, yeah, attempted murder is a more serious crime, but when we dig into the actual sentences of it, it's hard to see how attempted murder truly is more serious in the sentencing light.
Let me go. I'm going to lose the thought. One of the state's principal responses is that you're not pointing to any case law that applied the Uniform Operations Clause in this manner. And you've come back and you've given us Silva, and Silva seems to say that we're no longer in a world where, for purposes of ineffective assistance, we're bound by the law that exists. I wonder, though, whether you'd concede, and maybe you wouldn't, that even post-Silva, there still needs to be, let me ask it instead of asking rhetorically, doesn't there still need to be at least some legal hook for the argument that is there to be made? I mean, can you have an ineffective assistance claim based on a failure to make an argument for which there is no authority at present that supports the argument? Is that possible conceptually?
Your Honor, I think post-Silva, we really cannot just limit an ineffective assistance inquiry just to settled case law. But more importantly here, where it's the constitutionality of the statute and counsel was aware of the issue, as evident in the fact that she raised it in the Rule 402 sentencing reduction motion. At sentencing, I think it was unreasonable not to bring the issue to the trial court's attention during trial. And that's where the ineffective assistance.
And I guess that was going to be my question, sort of as a follow-up to that. I mean, counsel did raise this issue to the extent that at sentencing, she asked for the 402 reduction because of this issue. Even if it was ineffective assistance of counsel not to raise this argument at trial, it was addressed and decided against Omar post-trial. So does that go to prejudice? Does that indicate that there was a strategic reason why counsel didn't bring it up pre-trial or at trial rather than waiting for the sentencing? Talk to me about that.
Your Honor, we believe that it goes to deficient performance, that it was objectively unreasonable I mean, not to bring it up at trial, she still could have brought it up at sentencing, you know, in both, it wasn't either or necessarily. But by not doing it at trial, no longer, Omar no longer had the presumption of innocence, and the state no longer had the burden to disprove his self-defense. So it was just not a reasonable substitute in an ineffective assistance framework to wait until sentencing.
Well, on that point, the state makes what I think is at least a facially decent argument here on pages 31 to 33 of their brief, saying, look, counsel was aware of this issue. We know that because counsel raised it in the 402 reduction context. And the state posits that, hey, counsel could have been strategically deciding to run an all or nothing kind of a thing where the counsel didn't want to give the jury a middle option. Counsel wanted to go with guilty or perfect self-defense, complete acquittal, and then be able to come back and raise the 402 reduction question at the end. Seems like that might have been something counsel could have been thinking. I don't know. So we didn't get a chance to hear in a reply brief what your response is to that argument, and I'd like to hear it because I think that argument makes at least some sense. What's your response to the state's argument that there could have been strategic reasons for this, especially given the trickiness of raising a constitutional challenge to the statute?
Yes, Your Honor, we believe that an all or nothing approach was not reasonable just because the evidence was not strong enough for putting all the eggs in one basket of perfect self-defense. The words of Jackson, this court's opinion from 2015, an all or nothing choice just increased the risk that the jury would convict to avoid setting the defendant free. So it was just too great a risk here when there just wasn't a really strong enough evidentiary picture to prevail on perfect self-defense. So it would have been more objectively reasonable counsel would have opted to have all perfect defense and imperfect defense available for the jury.
Well, I mean, we've got a fair bit of case law through the years saying that running an all or nothing defense can be a reasonable strategy that isn't constitutionally deficient. I guess what you're saying is on these facts,
Yes, Your
it
Honor.
wasn't, and maybe you can help me understand what it is about this case that rendered that strategy unreasonable where it might be reasonable in some other case.
Yes, Your Honor. Perfect self-defense was problematic here because a reasonable juror could have concluded that Omar was the initial aggressor, for instance, or that he even was participating in combat by agreement. He's the one who came back to the house after the whole situation had diffused, the party was over. He came back to confront or apologize to Nate, whatever. There's multiple interpretations available there. And so typically in that scenario, imperfect self-defense is more appropriate than perfect self-defense. And a reasonable juror would more likely believe that Omar made a mistake of law rather than a mistake of fact. And that would put it more in land of imperfect self-defense, Your Honor. I see that my time is up.
Yeah, it's been up for a while now. We keep peppering you with questions, and we appreciate
Yes.
your patience with
Oh, of
our
course.
continued curiosity about this case. So thank you. You'll have your full time on rebuttal, and we'll turn the time over to Mr. Bauer now.
Okay, thank you.
Good morning, Your Honors. May it please the court. Jonathan Bauer on behalf of the state council. I think I'd like to start out with the imperfect self-defense issue that we've just closed up on, and then hopefully maybe devote the bulk of my time to the 23B issue. But as the court acknowledged, I think the state's primary argument here, and the easiest path by far for this court, is to simply look at counsel's decision as a reasonable choice, objectively reasonable, to pursue an all-or-nothing defense on the shooting charges, with the kicker that the jury still had the option, and in fact did, punish defendant for obstructing justice. So it is really a much more reasonable choice on these facts.
Do we need some indication in the record that that's what counsel was actually doing?
I don't believe there's anything in the record that necessarily indicates, puts that thinking on the record, but it's an objectively reasonable test. The question is, would that have been objectively reasonable under Strickland? And on these facts, it clearly is.
I mean, if just thinking this out right now, because we didn't have a reply brief to sort of close the loop on this, if we were to write an opinion saying that we're going to assume that it was, or that it could have been an all or nothing, even in the absence of anything on the record sort of saying that that's what counsel was thinking, I think the import of that, maybe I'll be proven wrong in 30 seconds, but I think the import of that would be that there could never be ineffective assistance for failing to ask for a lesser included, because I think we'd always be able to say that, right?
Well, I think ineffective assistance is pretty difficult to prove, and it should be. There's a strong presumption of reasonable behavior, and this, frankly, on a lot of fact patterns, including this one, is just a case where counsel can go either way, and we have to presume that he went that way for a reason. That's what Strickland says. It's a strong presumption of counsel's reasonable behavior. And again, this case does have additional facts where it's not a pure all or nothing, because he knows his client admitted on the stand, yeah, I got rid of the gun. And then, of course, there was the other testimony. I don't recall that there was express argument that he walked the jury through that. Hey, let my guy off on self-defense because you can punish him for that. I'm not even sure that's an appropriate argument to be focusing on punishment at the guilt stage. But nevertheless, the facts were there. This was an option he knew the jury had to wrestle with this complicated self-defense question, with the conflicting testimony, and to acquit because the state didn't meet its high burden to disprove it beyond a reasonable doubt. With the comfort zone that, hey, this guy did a bad thing. He's going to face some punishment for this incident writ large. That's an objectively reasonable choice for counsel to make. And then also knowing, as I think Judge Christensen pointed out, at the end, now I can go to sentencing and kind of point out this is so unfair that the state, charged me. The state's playing games. Of course, the prosecutor denied that on the record, pointing out there was probably not a lot of evidence of intent to kill here. That could be debated, but that's yet another distinguishing factor from just every case there can't be. And then I suppose the state's secondary argument on this failure to raise this uniform operation of laws argument is this is not by any means a clear winner. I realize that Silva came after
Can I ask you
Smith,
just, yeah, you're going there anyway, but let me just tee it up.
Yeah.
What's your understanding of where we're at post-Silva? Does there need to be some case law, in your view, that sort of would prompt the motion or not? Like, where are we at on that?
My understanding of Silva, and if my recollection is wrong, forgive me, my recollection is that obviously if there's settled case law in the sense of something that would support plain error, counsel can be expected to pursue it. I think Silva certainly opens up a broader avenue for counsel zealously representing his client to have duties that a trial court applying a settled law doesn't. However, it's my sense that where a Silva argument is really going to have teeth is where, perhaps the law is developing in other states and a defense has been recognized, or an element has been interpreted, something that's a trend in the law, and defense counsel may be obligated to be on top of that and argue, hey, Utah should get in line and recognize this defense.
What's a little bit different about this scenario is that we're dealing with a provision, at least under the rubric that they've given us, we're dealing with a provision from the Utah Constitution, the Uniform Operations Clause. I won't pretend to have any idea how many state constitutions have a similar clause, but let's just assume for purposes of the hypothetical that we're somewhat unique in that regard. Suppose that what we're looking at in an ineffective assistance claim is a potential issue for which there is just no law. We're operating on a blank slate. I'm coming back to the Silva question. So suppose we're dealing with a question for which courts just haven't looked at it, and appellate counsel comes in and says, well, trial counsel was ineffective for not making this new argument. Where are we at in terms of post-Silva ineffective assistance claims. Could it be possible for defense counsel to render ineffective assistance for not making an argument off of a blank slate, or would the state's view be, no, there's got to be something that nudges counsel to make the argument? Or do you just not know at this point?
Anything is possible, Your Honor, but the Strickland standard is the Strickland standard. A strong presumption of objectively reasonable action by counsel, and the burden on defendant on appeal to overcome that strong presumption. And I think in so many of our IAC cases, frankly, I tend to call them disagreement of counsel claims, because it's really just, we have counsel, we have a licensed, usually experienced trial attorney making a decision, we have a bad result, and we have an appellate attorney who, I'm one too, I love looking at things after the fact and finding problems and solutions, but, and then they bring a claim in front of the court. It really doesn't have anything to do with whether trial counsel had to do the other way. So I would say apply the presumption, apply the burden of defendant, and certainly on these facts in this case, both because of the reasons not even to go down that road to begin with, and then also because of the sort of novel state constitutional argument and the reasons I think I laid out in my brief as the distinctions I think Your Honor pointed out, different charges, different elements, different sentencing range. Just no deficient performance here, and frankly on these facts, well, I would disagree he would even have gotten the instruction on a uniform operations ground. But on these facts, the idea that there was a knife deployed and that Mr. Cortez, as I'm referring him to, perceived that is just contradicted by all the other evidence. The two witnesses, the victim himself testified he didn't pull a knife. His own friend said he drew the gun when he's walking behind him. He didn't tell his own cellmate, when he was telling him about the shooting. You'd think you might mention it. I shot a guy because he pulled a knife on me. That was never mentioned. This is incredible testimony. So frankly, I think this should go out on deficient performance on the reasonable choice to pursue an all or nothing defense, but there's also no showing of prejudice. Absent any questions of the court on the probation or something comment, I will turn to 23B.
Okay.
All right, on the 23B, I'd like to, before I get to the Strickland elements, basically talk a little bit about this motion and this affidavit and why it seems problematic to me to send this back for a hearing on this affidavit. It says what it says. And Griffin made it clear, we don't need an affidavit from these jurors. We don't need an affidavit from the actual witness. So that aspect of the affidavit is fine. The investigator talked to these folks, and that's fine. What we don't know, we don't know anything about that conversation. We don't know if it was cajoling, leading questions, done with trickery, perhaps in a different case, even,
But wouldn't that be the very reason to have a hearing, though, so that we could put them on the stand and ask them exactly what you just posited? What was it the investigator asked you that prompted you to say these things?
Well, I think there's some burden on the defendant to nail these things down up front, and I think that's the failure here. But my point isn't so much, I'm certainly not casting aspersions on the investigator in this case or opposing counsel. Sure. That's not the point. It's just that we don't know. And what we really don't know is I think it was Judge Harris asked, so we know the investigator didn't ask these questions because it's not in the affidavit. That's not true. He may have asked those questions and not gotten the answers he wanted and didn't put them in the affidavit.
You mean questions about additional ties to law enforcement?
Really any additional questions, Your Honor. I mean, this affidavit should be their best case. If there's good facts,
but how would we write that rule? If we were to write the rule saying we're not going to order a 23B remand because there were things that were not said in the affidavit, particularly that the other side might have wanted answers to, we'd be fashioning something of a rule of completeness for the 23B affidavit, and then we'd have a never-ending stream of those cases trying to figure out how detailed the affidavit actually has to be. Why isn't the simpler answer there? The burden on the defendant in the 23B motion stage, as opposed to the hearing and everything, is to give us facts which, if those facts are true, would support an effective assistance claim, full stop, and off we go to the hearing.
Well, I think the answer in this case, Your Honor, is the distinction is, here we've got a two-part showing before he can get relief on this juror problem. He's got to establish presumptive bias, which he may or may not have done with these answers, and then it has to not be rebutted. I mean, that's what happened in Arriaga on remand. That's what happened in Taylor. In the Court of Appeals, it was found that, that didn't happen in the trial court.
But this comes back to my question, though. At the motion stage, the defendant proffers, hey, here's the affidavit, here's how the things that I've put in the affidavit would be sufficient to prove a Strickland claim. And then the state comes back and they say, well, we could rebut it through X, Y, and Z. And the state is always going to be incentivized to come up with more potential sources of rebuttal than the defendant could anticipate or would want to anticipate. And now I'm back to my question of how we would write that rule. I mean, if we were to write the rule saying unless you affirmatively and preemptively rebut all the things the state's going to be concerned about, there's never going to be a 23B remand because you're always going to come up with something else, right?
I appreciate that. I think I would try, Your Honor.
I think you would try.
So let me give it one more shot at answering why this case.
Yeah, please.
I think it's a problem. Is that here it's not just nothing happened in the trial court. There were no relevant questions, and then I talked to the jurors and they said these bad things. I mean, there's literally been pre-rebuttal in the twice in the jury questionnaires and in person with the judge that has rebutted this, and to just ignore that in the affidavit and not ask that follow-up question. So you're saying you give more credence to police officers, help me explain to the court before we have this hearing and waste your time again and everyone's, time below. That's inconsistent with what you told the court, or is it? Or, how is it? I think there's tension there. If Your Honors don't want to write a rule about it, I certainly understand your concern about, our efforts to, perhaps.
I totally take the point you're
Sure.
making. I'm just wondering if it's more of a point for the hearing as opposed to the grant stage.
Well, and turning to the actual Strickland elements in this case, I think we've explored this a little bit perhaps and with the questions of opposing counsel, but I see the two cases that really kind of control here is the older case Arriaga and the more recent case Taylor. Those were cases that the alleged bias was on the record in the trial court, so that the district court had to react to it appropriately, counsel had to react to it appropriately. Here, aside from this idea that these guys were both cop adjacent, they could have both been cops. That's just not disqualifying if there is appropriate questioning. And here there was.
It's interesting that the challenge here is a 23B challenge to support an ineffective assistance claim for not asking more questions. There was a for-cause objection. It was overruled, and that's not being appealed. There isn't any contention here that based on the information the judge had at the time he overruled that for-cause objection, that was error. So we've got to focus on the ineffective assistance rather than on for cause, right?
Well, clearly the only claim here, 23B is purely ineffective assistance.
Right, and so the question, when I read this affidavit from juror number 6, the last paragraph in there, it does indicate bias. I don't know if you agree with that or not, but in paragraph 5 where he says he'd put more credibility toward law enforcement, he'd try not to be biased, but he'd lean closer to law enforcement. If he had said that at trial, he's kicked, right?
If he wasn't rehabilitated.
Right. So that's an indication of bias, right? And that is somewhat problematic, but we have to strain all this through the lens of ineffective assistance, right? So tell me why that's not a problem here.
I don't think it is an expression of bias, or at most it is what the case law talks about, a lightly held impression of bias. I think the number of people in this country, in this state, in this jury pool that would either say, I generally believe cops, or I generally think cops lie. That's one big circle of people who all have sort of preconceived notions about things. And then the answer is, well, yeah, but look, this is a trial. This is important. You're under oath. Can you set that aside? Are you going to listen to these witnesses, law enforcement and defense and others? And are you going to be fair? And under oath, or at least under penalty of law, both these jurors were asked that twice, and they said yes. They said they treat the defense and the prosecution the same twice. And I think that the judges
It's a little curious to me, and maybe it's more than a little curious to me. It's a little curious to me that there wasn't more follow-up questioning during voir dire about the nature of their connections. You know, we're sort of told, it's not vague, but it's not super specific how many cops they knew, who these people were, and so forth and so forth. It was a little odd to me as I read the motion and the response. I kept waiting for somebody to give me the paragraph, and I guess it just didn't exist, of somebody saying, can you walk me through who the cops that you know are? Can you walk, to give the court some sense of who exactly we were talking about and exactly how deep these ties were? I don't know if that's more of a comment than a question, but.
I mean, the record is what it is. It's certainly, you know, the questions were the questions. I think both jurors were very open in their questionnaires about their law enforcement connections. Now, some people are open because they want to get off the jury.
Right. I mean, I guess to make my comment more of the question I was thinking, I think that's the subtext of the argument the defense is making on appeal, which is for both of these jurors, they say things clearly indicating that they've got fairly extensive ties to law enforcement, and any reasonable counsel who's sitting there thinking, do I really want this person on the jury, would have immediately jumped up and said, we really need to explore this so we can figure out how deeply held their law enforcement adjacent views may be. And it almost seems like the problem that the defense is getting at on appeal is defense counsel just didn't give the court enough grist to figure out the four-cause challenge, really.
Well, asking further questions is, you know, certainly one of the many, many ways that a counsel could have been effective, but that doesn't mean that the way he handled things here wasn't. I mean, all of these questions would have ultimately gone to, I know you've just said under oath twice that you're going to be fair and you're not going to be, you know, but here I am essentially calling you a liar, or trying to establish not a liar, but an unconsciously biased person. You know, that's possibly going to aggravate these jurors to begin with. But I think the other aspect of this, there's case-specific reasons that this was just not a path to necessarily go down. This is, as Arriaga talks about this, I mean, this isn't your stereotypical cop credibility case where it's all about the traffic stop and the reasonable cause, and then he assaulted me, and then I smelled drugs or found drugs or whatever. This is not a pure cop credibility case in that sense. It's much closer to a case where, I mean, these are essentially lay witnesses. It's essentially the three witnesses to the shooting, and everything else was pretty much gravy. And Arriaga recognized that I don't have the paragraph number. Also, this is a self-defense case, and you know, I'm not sure who's more sympathetic to self-defense at some level than people who are cops or who love cops or know cops. They understand that sometimes you have to use deadly force in a justified way, and they're probably more comfortable with that than the average juror, if that's your argument. Now, he made that argument, the jury didn't buy it, but that doesn't make it not a consideration up front that you don't necessarily, in a case like this, want to exclude people who are police officers, gun aficionados. I mean, that's kind of at some level, your base. Well, at any rate, I think that's about what I have on deficient performance. And I guess on prejudice, I mean, obviously, it's if the actual bias is established, you know, that meets the prejudice standard. I understand that. But I think the problem here is we have two sworn statements, you know, 2 years prior to this interview, and then 2 years again prior to some future hearing we're going to have if this gets remanded. We have the sworn statements, and these later statements are pretty much contradictory to that with no explanation. And we have, you know, in the trial court record, we have the prebuttal. I mean, that's the questioning that didn't happen in Taylor and the questioning that did happen on remand in Arriaga. And we have it on the record here in this case. So there's just not a showing of the remand that is, you know, it's going to, any 23B remand is going to, you know, impose on the trial court, the attorneys, the defense expert, whoever has to get called into this. But these are jurors. They showed up coming up on 4 years ago now. They did their job. They answered a couple of phone calls 2 years ago, and then they're going to get called in to essentially get raked over the coals on something they already answered under oath twice in 2021. It just doesn't seem like something the court wants to encourage absent a a strong showing that relief is going to flow from it. So if the court has no further questions, I'd ask the court to reject the 23B remand motion and to affirm the convictions below. Thank you.
Thank you, Mr. Bauer. Ms. Ellison, back to you for rebuttal.
Your Honors, I would like to make 3 points on rebuttal. To begin, going back to the question of like what sort of specific questions could have been asked, just to frame it again, in ineffective assistance counsel land, that's where we're at. It was just not a reasonable strategy for counsel not to have fulfilled her duty to ensure an unbiased jury by asking more specific questions. There are a whole host, just for examples, like we've been talking about, there's so much we don't know about who particularly they had close associations with for Juror 6 in law enforcement, who exactly they worked with, how like Juror 6's interactions with the court when testifying on behalf of the state about his sting operations, like how those experiences would have affected his ability to weigh evidence and assign burdens of proof and weigh credibility and whether that would lean him in favor of one party or the other, and whether perhaps either juror could believe that mistakes can be made by the state or by police, or even would you want to be on a jury where there is law enforcement participants as jurors? I think there are a whole range of questions, and just more importantly, at the jury selection stage, it's really incumbent on the trial counsel who is has a better grasp of the facts of the case, right, than the trial court to take the lead in making sure there is some further investigation of the potential bias. And that's why it was unreasonable here for counsel not to have done so, just to simply have relied on the motion for cause without first establishing actual bias. And second point, Judge Tenney is correct about the Rule 23B standard. And if the state does think other facts could come out, again, that's just why a 23B hearing would be the best route for this to take. And just to reiterate, it's the court and the state that has the duty to ask like the rehabilitative questions, and that could occur at a 23B hearing. And then finally, going back to the imperfect self-defense and the question of post-Silva, where we are, first of all, we're just not working from a blank slate here, because as was discussed, we're dealing with a constitutional provision, the Uniform Operation of Laws. So we have that to rely on, and it's a counsel's duty to be zealous and guard the client's constitutional rights. And so, although it may have been not the most obvious argument to have made, it was a battle that competent counsel would have fought, and it was unreasonable not to do so. And with that,
Can I take you back to the jurors? We've been talking a lot about juror number 6's affidavit. I guess I wonder if you think that the claims you're making with regard to juror 6 and juror 7 are equally strong, or if you perceive that there might be a stronger claim with regard to juror 6. When I look at juror 7's affidavit, I really don't see juror 7 saying the same kinds of things that juror 6 was saying in terms of, I'd put more credibility toward law enforcement, I'd lean closer to law enforcement. Juror number 7 seems to stick to his guns on this and say, yeah, despite the fact that my father and my brother were law enforcement officers, I would still apply the innocent until proven guilty standard. And he doesn't seem to countermand anything about his previous answers that he could be fair and impartial. So help me understand how you get to where you need to get with regard to juror 7 specifically.
Your Honor, I would say that in comparison, juror 6's statements are more concerning, admittedly, but juror 7 also states, he believes is typically not the case where police have arrested the wrong person in his perspective. I think that warrants just further inquiry, especially that he says throughout his life, he's been around law enforcement officers in a very close and personal relationship. So I think that is worth exploring and understanding how it would affect his view of the state and the police, law enforcement, and the defense, and whether push comes to shove, if he could if he could believe a defendant's version of events. He also expressed surprise that he was even picked to be on the jury. And he thought the prosecutor liked him. So I think there are enough concerning statements that warrant further investigation. So
What do you make of Mr. Bauer's point that, hey, if we granted a 23B remand on these facts, where at trial they were unequivocal that they could be fair and impartial despite their law enforcement ties, and later investigators go and find that there might be some cracks in that unequivocal answer. The argument here is, well, that would incentivize everybody to go talk to every juror 2 years later and ask them questions about things they were unequivocal about previously, and that's not a regime we want to encourage. What's your response to that point?
Your Honor, I would say one way you could possibly avoid that is you say the jurors had a chance to rebut. Like, they were asked in a group of people, will you fairly apply the presumption of innocence? But instead, you could require that the problematic jurors with potential bias be asked individually, avoid peer pressure.
But what about here where they were asked individually in a questionnaire where they got to fill that out in the privacy of their own home and think about that, and nobody else is looking at them raise their hand that they're going to be biased? Does that matter?
I feel like that is not enough still, because we know that a juror cannot rebut his own bias. The presumption, just as we get from Taylor, that a juror's assurances alone are not enough. I think a questionnaire, they haven't been able to really, that's the point of further questioning, is to help explore, maybe uncover, because the whole problem with prejudice is a juror is not aware of it. And so I think it only is revealed through questioning that elicits responses to discover how it affects their viewpoint. And I think a questionnaire alone is insufficient to fully uncover and investigate a potential bias. And if there are no further questions, we ask this court to reverse, or at the least to remand for a 23B hearing on the jury issue. Thank you.
All right. Thank you, Ms. Ellison. Thank you, Mr. Bauer. We appreciate you coming down this morning and helping us understand this case a little bit better. We'll take the matter under advisement and issue a decision as soon as we're able to. Court's adjourned. Thank you.
All rise.